Good morning to everyone. We want to thank everyone for joining us today. I want to say I still think February 8th is still merits saying Happy New Year to everyone. So Happy New Year to everyone. We're looking forward to a good season. We're still letting people in. Thank you for taking time to join us. This is our first seminar through Human Capital. And just to give some of us that maybe aren't familiar with human capital, let me introduce myself as Javier Rodriguez. I am the founder of Human Capital. Many of you know me from my former life under Risco Insurance Services, where we have merged with Enzo now. Human Capital is one of our consulting firms, and really our focus there is to help businesses in their risk management and labor related issues. So we're excited to kick off the series. There'll be 4 seminars we want you to put on your calendar. We don't have every month. We have one slated for March, April, and May, and we'll talk about some of the topics. But once again, thank everyone. I want a special shout out and thanks to Juan Torres for being part of this, leading off this year. So we're excited to have him. I'll talk a little bit more about Juan, and we have Carmen. Want to thank her and for her participation today. She'll be our a speaker coming up soon. Also thank some of our people that work in the background. Jennifer Estorga, thank you for helping me put this together, and Agustin for being part of this also, and we're a lot of background, Mei Lee. So we have a lot of people working, putting this together. So appreciate everybody coming together on this endeavor. I think I'll give it a couple more minutes. People are logging on, and just a couple housekeeping rules. If you notice that you don't have your video, it's been turned off. That's on our side. We try to keep the distractions to a minimum, so we turn off the video. Sorry about that. And also you're on mute, but you can communicate us through the text feature on the Zoom meeting. So that is there. After the presentation, Juan's presentation, we will have a Q&A session. So if you have any questions ahead of time, you could put them on there, and we will try to endeavor to make sure we address those. So we'll start today. Is our 2023 labor law update. Human Capital, once again, is hosting this. We thank all of you for joining us. California is a tough place, so we're going to try to make to do business. We're going to make it a little bit easier to navigate through this. So Human Capital. As I said earlier, Human Capital is a consulting firm that I founded in 2019. Really, our focus is risk management, is to come up with solutions, labor-related solutions on different fronts. So this is something that we've endeavored prior to the pandemic, and it's kind of been prophetic. It's helped us to deal with the issues at hand today. So you can reach out to me if you have any questions regarding that after the seminar, or just send us a text. I want to thank our partners that sponsor us. Southern California Corporate Growth Partners, John Gutierrez being the president. I want a special thanks to him for his partnership and allowing us to put these together. Really, their mission is to strengthen businesses in the community and establish both educational, civic, business, and global partnerships. So it's a great dynamic firm. Their website is on the bottom. They do a wide variety of services for businesses. So take advantage of their services. If you need to know more, let me know, and we could definitely put you in touch with Juan and his team. They got a great team of people and resources. So let me move on to the next screen. King Solomon, one of the wisest men that ever lived, one of the most successful business men that ever lived, wrote a proverb, many proverbs, but 11:14. It says, Where there is no counsel, the people fall. But in the multitude of counselors, there's safety. And that's just a great principle. Sometimes I remember my 40 years in business, sometimes feeling like an island and just, all the challenges that came around and trying to resolve things where there had been people around me that had already resolved many of the issues and had learned how to address them. And that's what the safety in a multitude of counselor is. You look at people around you, you get a network, and we hope we can be part of your network to bring solutions and suggestions to answers to sometimes perplexing questions. So that's what we're going to do today. We have a multitude of counselors, and I've always surrounded myself with really great people. Some are here today that just have guided me and been that shiny light when things have been a little dim. So we want you to feel that we are that resource for you. March, I don't have a date. I will have it out next week, but we're really kind of looking for, I think, the 16th of March. In just about a month from now, we will have our next webinar, and it's really it's a financial issue. It's a component of the employee retention tax credit. It's a hot topic. In 2021, Congress changed the CARES Act. If you remember, many months ago, we talked about the CARES Act in 2020. That's where you had the PPP loans and many other things to help businesses during the pandemic. Well, there's been some changes in 2021, legislative changes that have allowed businesses not only to take advantage of these the PPP loans, but also to get employee tax credits. In the past, you couldn't do both. Now you can. So we'll talk about that. We'll talk about all the options businesses have to recover some tax money. So that will be coming up. That'll be an exciting, very robust webinar in March. We have a YouTube channel. Just go into YouTube and then put Human Capital, and you'll see some of our past webinars. So they'll be there. This one will also be there probably by tomorrow. So just if you missed any part, you want to go back, look into our YouTube channel. Okay. We've all seen this. Now leaving California. It's about 300,000. It says about 320,000 people are leaving California every year. That's a lot of people. But California is still, I'm not sure if it's the 5th or 6th largest economy in the world. It's still a golden state. And I think that many people are leaving because I think some of them have found opportunities, but I think a lot of them were not able to navigate California. I think we've come into a new season, and it's not going to change. Doing business California will still be profitable, but it'll be harder to do business. So the better businesses, the ones that are more attuned to and able to pivot, are the ones that are going to be successful, and the other ones are going to go to other states where the requirements are less. So we encourage you to join us. We provide this to make it a little bit easier to stay in California. I don't want to leave. I like the weather, so I'm staying here. I'm a California man, so I am not leaving. Something's interesting that's coming out, with the pandemic. Many things have changed. So, I've been talking with Carmen, and thank you, Carmen, for joining us. She'll be one of our upcoming speakers, and she'll be talking about this new phenomena. Maybe you can give us a tidbit, whet our appetite, Carmen, on what is quiet quitting.
Sure. Thank you, Javier. Thank you for inviting me. And so quiet quitting, what it's been really referring to, and how employees look at this is really like not depleting yourself at work, but rather just doing what's expected, doing the minimum, sometimes even doing less than what's expected. And so, what we'll be talking about is, why is this happening, first of all? How can you recognize it? And what can you do? What can you do as an employer to make sure that your employees aren't quiet quitting, right? And I think I also want to mention that, the most recent phenomenon here is quiet quitting, as what I just mentioned, but the second one is quiet hiring. And that's another topic that's come up. So, hopefully we'll be able to touch on both of these topics when we get to connect with your listeners again.
Carmen, awesome. We're excited. Tell us a little bit, if maybe somebody wants to know a little bit more or needs, this is your information. So tell us, is this how they can get in contact with you?
Thank you, Javier. Thank you so much. Yes, and for those of you who I haven't had the honor of connecting with yet, my name is Carmen Torres. I am the CEO and the Chief Specialist of My HR Specialist, and we provide HR support to business owners and nonprofits who typically don't have an in-house HR, and we guide you, support you with your handbooks, creating, developing, implementing policies and procedures. Simple questions like, how do I handle this situation with my employees who are late all the time? Or, is this the proper way to terminate? And so you can reach me any of these ways by email, by phone, scheduling a session with us. Look us up on Facebook, and our website is www.myhrspecialist.com. And we look forward to supporting you with any of your HR needs.
Great, Carmen. And so if anybody has any questions, use your phone, take a quick picture of this screen, or if you want to come back to us, put it on the chat and we'll pass on that information. Gracias, Carmen. Thank you. Look forward to the next webinar.
Thank you.
Okay, so now we're going to talk about why we're here today. So let me go over real quickly today's webinar agenda. It's the new legislative matters. The whole point is every year laws are changing. So we're going to Juan is going to kind of guide us through this gauntlet. He's going to talk about pay disclosure. He's going to talk about cannabis use. Some of the amendments in the California Family Right Act, contraceptive equity, COVID still with us, and some COVID legislation. So we are going to start. Looking forward to Juan's presentation. Let me introduce Juan Torres. Juan is a personal friend of mine, and we've worked together for many years. He's a very skilled employment law professional, and that's what he's done. That's his core. He does other things, but his core concentration is in labor law, and he's been a great asset to our team, to our clients. Many of you know him, very, very well informed on what's happening, and understands and seasoned. Even though he's very young, he's seasoned. He's had many years of experience and in business matters. So it's always a privilege. Juan, gracias. Thank you for joining us today. Privileged to have you, and we're excited to see what 2023 has for employers.
Thank you, Javier, for this opportunity once again to provide some updates. Obviously, we're not going to go through everything that happened in 2022, but we are going to go over some of the legislation that I think may benefit the audience, and updating and keeping updated with regard to what's happening, particularly with new legislation that has become most of the legislation that I will speak about became effective on January 1 of this year. So it's already in place. So if you do not know of these updates, then you should definitely pay attention and try to implement where implementation is necessary. In terms of how young I am, I began practicing in 1986. That's when I graduated from law school, and I've been with my law firm Music, Peeler and Garrett, as you can see on the slide, since 1990. So it's been a while. And generally speaking, I'm a litigator. What that generally means is that I'm an attorney that goes to the court. We have generally two types of attorneys, one that never goes to the court, just tries to put deals together. And I'm the lawyer that comes in when those deals go sour. And with regard to employment litigation, when an employee has sued the employer, then I come in to represent the employer, and that's all we do. We represent employers. So we don't represent employees. Not because we don't want to, it's just because of the conflict issues that may arise if we represent both. So let's go to the first slide. Okay. This Senate bill, and this is California legislation, all of it except for the last, the EEOC that we will talk about. But this is California Senate Bill 1162, and it relates to the pay scale disclosure. This legislation is due to what has been in the news and in media for years now in terms with regard to women not being paid the same as male employees for performing the same type of job. So anyway, this legislation came about as of January 1, 2023, became effective, and it provides that, generally speaking, some of the provisions is that all employers must provide to employees who request it the pay scale for his or her current position. So if an employee comes to you and says, hey, I would like to know what the pay scale is, and we'll go over what the definition of pay scale is, then you are required to provide them with that information. And then the other one is that all employers with 15 or more employees. So this is limited to only employers that employ 15 or more employees. They must include the pay scale information in any job position posting. So if you are out there trying to attract the best type of employee or individual that can perform the job for which you need him or her, then you need to post, and you've posted for the public's view the availability of that position, then you must post the pay scale along with the job and description of the job, etc. Next slide. Okay, so this applies to not only the employer, but it applies to anyone that posts a job for that employer. So if you've hired a recruiter, or if you posted an announcement in a newspaper, then that posting by the recruiter or by the newspaper has to include the pay scale. So you cannot get away with not having to comply with this requirement by hiring a third party to do the posting. Okay, so what does pay scale mean? It means generally the salary or hourly wage range. So it's a wage range that the employer reasonably expects to pay for the position. That is somewhat vague, of course, and as most laws that are passed are vague because it leaves a lot of wiggle room. But generally speaking, it pertains to the hourly wage range. And that's what a pay scale means. All right, next slide. Okay, next is also related to this wage equity issue. It's Senate Bill 1162, and it pertains to wage transparency. And what it generally provides is that the labor commissioner, the California Labor Commissioner, is authorized to investigate and order an employer to pay civil penalties if this job posting requirement has not been complied with. So if someone points a finger and makes a complaint to the labor commissioner, the labor commissioner can come in and do an investigation with regard to this job posting requirements, and order the employer to pay civil penalties. The penalties can range for up to $200 per violation, and the person, the individual, the employee who claims to be aggrieved, who claims to be harmed by this job posting failure, may file a lawsuit. So generally, sometimes laws do not provide an employee with the right to proceed with a claim, but this one does, and they may file a lawsuit for injunctive and other relief that the court deems appropriate. Injunctive relief, what that generally means is that it's a court order directing, in this case, the employer to do something or not to do something. And in this case, obviously, the injunctive relief would be to order the employer to comply with the posting obligations. And then with regard to the relief that the court deems appropriate, that has not been defined. So at this point, until some regulations are passed, which hopefully defines this term and provides some limits as to what the court can deem appropriate. At this point, I guess any type of relief, monetary or otherwise, the court has the authorization under this legislation to institute. And next slide. Next slide. Okay, thank you. Again, continuing with this Senate Bill 1162, and it's the wage data record keeping. This legislation also provides that all employers, all employers must maintain a record of each employee's job title and wage rate history throughout the employee's employment. So this is a heavy requirement. And the employer must keep that record for at least 3 years after the employment of the employee ends. What I would recommend when it comes that the employer keep these records after the employment relationship ends for at least 4 years. And here's the reason for that, is that as some of you may know, generally speaking, the statute of limitations for a wage and hour claim can be up to 4 years. So that is the reason. So if someone sues, an employee sues for an alleged wage and hour violation, that employee can go back 4 years from the date that they filed the complaint and that'll be the period during which they can recover whatever wages they claim they were not paid. And the failure to maintain and keep the record results in what is called a rebuttable presumption in the employee's favor. A rebuttable presumption means that unless the employer can prove that there has been no violation, then if the court will go with the employee's position. So it's a presumption that the court makes, but it is rebuttable by the employer. So it provides with the employer with the opportunity to try to overcome this presumption. Next slide. Still with 1162 is the wage data reporting. Now, this one applies only to private employers with 100 or more employees. And I don't know if this applies to anyone that is on this webinar, but generally speaking, such employers must report the pay data to the California Civil Rights Department, which used to be the Fair Housing and Employment Commission, and they must provide it each year by the second Wednesday of May of each year. And as you may recall, there was this requirement initiated a couple years ago, but it has been updated with regard to how the employer can comply with its requirement. And the report must include the median and mean, not a range, but a median and mean hourly wage rate by each combination of race, ethnicity, and sex for each job category. So this legislation, the purpose of it is to try to prevent discrimination based with regard to the hourly wage that is paid to an employee, to make sure there's no discrimination based on these protected categories. And what this legislation did, it deletes the provisions that formally authorized the employers to submit what is called an Equal Employment Opportunity -1 report in lieu of the wage data report that that is now required to be submitted to the California Civil Rights Department. And also a report that was referred to as the Consolidated Report for Multiple Establishments. Next slide. Okay, so now let's go to the California Family Rights Act and some of the updates and amendments that have been made to this act through legislation. And first, we'll start off with AB Assembly Bill 1041, and as indicated here, it's been effective since January 1 of this year. So what this is pretty significant in that an employee can designate what is called a designated person. So a family member under the California Family Rights Act now includes a quote designated person, quote, which and as indicated here in the last entry on the bottom of the slide, designated person means any individual related to the employee by blood or whose association with the employee is the equivalent of a family relationship. So this leaves some wiggle room. And I mean, how are you going to be able to prove that this designated person is related by blood? I guess unless you have the employee and the designated person take a blood test and to see if in fact they are related by blood. So this could be somewhat cumbersome. So what an employee can now do is identify such a designated person for whom the employee may take an unpaid, so the CFRA provides for unpaid leave of absence, or a paid leave of absence under the California Healthy Workplaces, Healthy Families Act. So next slide. Next slide. Okay, now we have Assembly Bill 1949. Again, it's a CFRA amendment, and this also became effective January 1 of this year. And what this provides for is that employers with 5 or more employees, they are now required to provide to employees up to 5 days of unpaid bereavement leave. And the bereavement leave, however amount it is, up to 5 days, or whatever amount it is, up to 5 days, must be taken within the 3 months of the family member's death. So after the 3 months, there is no obligation by the employer to provide this bereavement leave requirement. But then what about if there's 2 or more family members that pass away at different times during the year? So at this point, my recommendation would be that this bereavement leave requirement applies each time a family member passes away. And the 5 days do not need to be taken consecutively. They can be taken one day here, one day there, as long as the time is taken within the 3 months of the family member's death. So the employer would, at least I would recommend, if an employee does request this bereavement leave, that that a certificate of death be provided as evidence of the family member's death. Next slide. All right, so now we go to what has been a really huge issue in the employment area, which is the cannabis use by employees. And so now we have this legislation that is going to become effective next year. So it's not effective yet, but get prepared. It'll be effective as of January 1 of next year. And this is Assembly Bill 2188. And under this legislation, employers, all employers may not discriminate against, excuse me, against a job applicant or employee because of cannabis use off the job and away from the workplace. So they can, the employer can still take a drug test, but the drug test cannot be for purposes of recording a non-psychoactive cannabis metabolites in hair, blood, urine, or other bodily fluids. Don't ask me what metabolites means because I have no clue. There's non-psychoactive. I've done some reading on it, but I don't consider myself to be an expert in trying to explain to you what that means. However, this requirement of that you cannot discriminate for off the job and use of cannabis and away from the workplace, that does not apply to employees in the building and construction trades and in positions requiring a federal background check or a security clearance. So there is that exception. Next slide. Actually, I wanted to, let me just back up. Don't change slides, but let me just, yeah, okay, thanks. No, back up. Yeah, okay, just stay there. The, an interesting question is, if you cannot discriminate against an employee or a job applicant for the use of cannabis off the job and away from the workplace, what about during a lunch period? As you know that, as you may know, under California law, all employers are required to provide non-exempt employees a meal period of at least 30 minutes, and the employee can leave the job site or workplace. So you cannot require that employee to stay at the job site during that lunch period. What about if an employee uses cannabis and then they come back after lunch period? And can you take any action under this legislation? You cannot. But what about if you notice that this employee is wobbling or seems to be under the influence? Then I would say that under that situation, you could make a potentially viable argument that you can take some action and maybe even inquire of the employee. But be careful in doing that. So use your best judgment in doing that, and maybe having the employee take a drug test. All right, next slide. All right, now we go to this Senate Bill 523, and it's California's response to the, as you may know, the famous or infamous Supreme Court case that last year that did away with a woman's right to an abortion under the Constitution, U.S. Constitution. That Supreme Court determined that there is no such right. But states are free to impose and implement legislation that does provide a woman with the right to have an abortion. So here, this became effective again, also on January 1 of this year. And what this is pretty significant in that it adds, and which rarely happens, it adds what is referred to as a reproductive health decision making is being now a protected category under the Fair Employment and Housing Act. So just like race, sex, sexual orientation, disability, which are protective categories under the Fair Employment and Housing Act, now reproductive health decision making joins that group. And employers, all employers, cannot require as a condition of employment or an employment benefit, health insurance, for instance, that the employee disclose information pertaining to the employee's reproductive health decision-making, or require a job applicant to do the same. And reproductive health decision-making includes, which again, this is vague and general, a decision to use or access a particular drug, device, product, or medical service for reproductive health. And under this medical service, certainly abortion falls under that, and maybe a device and drug falls under that, that a woman may take to induce an abortion. Next slide. Now we go to the COVID legislation, or some of the COVID legislation that was passed by the California legislature last year. And we begin with the Assembly Bill 1751. And what this provides, and it's became effective at the beginning of this year. And again, we have this rebuttable presumption for purposes, only for purposes of workers' compensation benefits, that an employee's COVID-19 related illness was sustained in the course and scope of the employment. So if an employee comes to you and says, I've been diagnosed with a COVID related illness, and I contracted it here at my workplace, then there is a presumption that what the employee is stating is true, unless the employer can prove that that is not true. So an employee can say, look, I sustained this illness and I would like to apply for workers' compensation benefits. So if an employee comes to you, then you must fill out the necessary, immediately fill out the necessary workers' comp claim benefits documentation, so that a claim can be processed. And this presumption, however, only goes through the end of this year. But I'm almost certain that because this COVID situation will continue to be part of our lives, that this presumption law will be extended beyond that. So look out for this. Next slide. Now, Senate Bill 1044, this applies to COVID situations, although it's much more general. It applies to what is called any emergency condition. So all employers generally cannot take or threaten an adverse action. For instance, change of position, or have the employee go home, or have the employee, you reduce their wages, or you take some some disciplinary action. So that's what adverse action means. You cannot take any such action against an employee for the employee refusing to report to or for leaving the workplace or work site if the employee has a reasonable, again, we have this vague term, reasonable belief that the workplace or work site is unsafe due to an emergency condition. So emergency condition can be, for instance, that, and with regard to COVID, that there's a COVID, for lack of a better term, infestation at the work site, that a lot of employees have contracted or are suffering from a COVID-related illness, and that employee, the non-ill employee, comes to you and says, "Look, I'm leaving the workplace. I don't want to be in danger of being exposed." And I have a situation right now where, and I think more and more of these cases are going to be filed. Several employees have filed several lawsuits against a certain employer, and basically what the employees are alleging is that they became ill at the workplace because other employees were suffering from COVID, and not only the employee became ill, but family members who live with the employee also became ill, and those family members are alleging that they became ill because the employee became ill. So the issue becomes, did you in fact, employee or family member, become ill because of your exposure, by the employee's exposure at the workplace? So if the employer can prove that it is not, and this is what is going to have to be done in this case, the employer can prove that the illness by the employee was not due to exposure at the workplace, and unless the employer can do that, then there's potential liability, at least to the employee. Now, the issue of the family members, I think that's going to be something that we'll see what the court decides, and what the court decides most likely will be taken up on appeal. And again, continuing with this legislation, and employers cannot forbid an employee from accessing their mobile or other communication devices during an emergency condition to seek assistance, to assess the safety of the situation, or to communicate with any person to confirm their safety. All right, next slide. Continuing with this legislation, so what is an emergency condition? It generally means the existence of either conditions of a disaster or extreme peril to the safety of persons or property at the workplace or worksite caused by natural forces or a criminal act. So this is pretty general. It does not cover only COVID situations. And also an emergency condition refers to an order, generally speaking, by the government to evacuate a workplace, a worksite, a worker's home, or the school of a worker's child due to a natural disaster or criminal act. And the orders can certainly be by the police or fire department personnel. And an emergency condition does not include a health pandemic. So just because we have this COVID situation that exists outside of the workplace, that is not enough to meet this emergency condition definition. Next slide. So now we go to the EEOC's new COVID testing guidelines. This has been a big issue for employers in trying to comply with these guidelines, which are constantly changing. But I think we're reaching some kind of settlement in this regard. So under, and this is the Equal Employment Opportunity Commission. This is the government, federal government agency, not a state agency. So under these federal guidelines, employers may or can test employees if it's consistent with a business necessity and job related. So if you employ an employee who's a driver, you hire them as a driver, then potentially you can test for this if the driver is suffering from is suffering from an illness, or potentially maybe suffering from a COVID-related illness. And employers can require an employee who contracts COVID-19 to provide a note from a doctor, or other qualified medical professional, or the employer can follow the Center for Disease Control guidelines. And the employers may screen new hires for COVID-19 symptoms, but the employer cannot require antibody testing. I believe this may be the end of it. Is this the end of it? Oh, here we go. Okay, there's another federal legislation, and it's House Rule 4445. And it amends the Forced Arbitration of Sexual Assault and Harassment Act. And some of you as employers may have arbitration agreements or form arbitration agreements that you have new hires or current hires that have not signed it. I have them sign such arbitration agreements. Now you cannot force, generally speaking, you cannot no longer enforce an employee as a condition of their employment to sign such arbitration agreement. And arbitration, for those of you who may not know what it is, generally speaking, when an individual files a lawsuit or has a claim, there's several ways by which that employee can file the claim, but two of the ones that are the most that are the most seen are filing the claim with a court of law, whether it's California state court or a federal court. And then another regular way is the filing for an arbitration proceeding. And excuse me, an arbitration proceeding is very different from a court. And one of the major differences is that whereas when someone files a claim with a court, the information that is filed with the court, generally speaking, is public information, and anybody has access to that information unless it's been sealed per a court order. But in an arbitration proceeding, it is not a public proceeding. It is a private proceeding, and therefore the public does not have access to the information. So that's why employers a lot of times prefer an arbitration proceeding as one of the reasons. And another reason is that an arbitration proceeding, another major reason, is that generally speaking, not always, but generally speaking, an arbitration proceeding to have a hearing where an arbitrator decides with favor or against the employee or whoever the claimant is, generally speaking, takes much less than a court proceeding, particularly nowadays when a court proceeding may last 4 to 5 years to finalize, where an arbitration, sometimes it can be done within 1 year. And then with regard to discovery and anything else that usually happens in a court proceeding, that may be limited as to what information can be requested from the employer in an arbitration proceeding. And now this, and what this amendment does, so employees with it provides employees with a sexual assault or harassment claim with the opportunity not to proceed with that claim in an arbitration proceeding even if the employee has signed an arbitration agreement or an agreement whereby the employee has waived their a right to file what is called a class action. So an employee can file a class action when on behalf of other employees who are alleging sexual assault or harassment, even if the employee has signed a class action waiver agreement. And sexual harassment or assault claims of such nature can be filed by both women and men. And this amendment has been in effect since March 3 of last year. But I just wanted to bring it up because it's an important piece of legislation that must now be complied with. I think this is the last one.
This is the last one. So thank you so much. I want to see if we can take a couple questions. Is that okay, Juan?
Certainly.
Yeah, I know, Jennifer, we have one that's already on the chat. And if anybody has any questions, please put it in the chat. We're going to try to answer the questions, as many as we can. But Jennifer, you want to read the first one? And I believe it had to do with cannabis use.
Yes. So someone asked, what about airline pilots?
That's an interesting question. The airline pilots, as you probably know, they are generally under what is called a bargaining agreement. They're unionized. And so generally speaking, you would have to look at that bargaining agreement, which most likely would have some provisions concerning the use of cannabis. But if there is no such agreement and they are a pilot in California, employed in California, then yes, I would say that this will fall under the exception, that it's for purposes, it's because of the nature of your business. If you own an airline, or if it's a private pilot, and there's certainly a safety issue when it comes to pilots.
Thank you, Juan. Also, if anybody wants to, any questions, please put it on the chat. But within that, as a clarification, Juan, you mentioned, so under this cannabis rule, can you address how that, many people in their handbook have they have put in what they call a drug-free workplace. And how do the two, do they clash with all the, with the legalization of cannabis? Employers in general want a drug-free workplace. How do they ensure they're not overstepping their bounds, but at the same time protecting their business and the employees and clients?
Yeah, you can still have a policy that provides for drug-free employment, but this is an exception in that you cannot legislate the off work site or workplace use of cannabis. So and that's why this lunch period issue could potentially be important, in that you have an employee who goes out during their 30 minutes or however amount of time you provide, if it's more than 30 minutes for lunch periods, and uses cannabis and comes back to the job site. So that can become an issue. So I would suggest that if you are in that situation and you suspect or even saw the employee off the work site using cannabis, then I would suggest that you call an attorney, and for that the attorney can provide guidance based on the fact pattern that applies to that situation. But generally speaking, you can still say you cannot use cannabis while you're working, or even at the work site. Even if you take your meal period at the work site, then you can you can forbid that employee from using cannabis.
Thank you, Juan.
We have another question. So the next question, can a salesperson in the transportation industry be categorized as statutory employee?
I'm not sure what statutory employee, what is that referring to? Is that exempt or non-exempt? Is that what that refers to?
Yeah, the question, yeah, maybe if they can, the person that asked that question, can they elaborate on that? We'll move to the next question and we'll get back to that question. But if you could elaborate statutory, what do you mean by that? As Juan said, exempt or non-exempt, hourly exempt. But let's go to the next one.
Okay, the next one, for employers with over 100 employees, the requirement to report pay data to the California Civil Rights Department, how is this reported?
Yeah, there's what you would have to do with regard to the guidelines that have to be followed. There are guidelines that are stated in the legislation that directs as to how it is how you are to report that information. I can provide that information. I don't have it at my disposal at this point, but I can certainly provide that information if you send that information to my email, which is in the first slide.
I will put that slide in there so we can do that. Put that in there. Okay, and then we had this is another question is on bereavement. In there, Juan, it said up to 5 days.
Right.
Up to 5 days. My understanding means 1 to 5, but it seemed in the explanation we were using 5 as a benchmark. So can a firm offer 2 days, 1 day, 3 days for bereavement under the 5, or does it mean 5 is the minimum days that can be allocated for bereavement?
Yeah, it's the latter, as a minimum 5 days. Yeah.
Okay.
Yeah.
Okay.
But so the employer can certainly provide more, but
Right.
it must provide at least 5 days.
Okay, great. I don't see any more questions, and if you have anything, Juan's information is there. Feel free to email him, and I'm sure he'll answer that. But
Or you can certainly call me. I prefer the cell, and that's the 702-0243 number.
Great. So I would, for those that want to know more about what Juan does and have more questions, take a quick snapshot on your phone of his information, and I'm sure that Juan will be more than happy to talk to you.
And Javier, it might be if I just a couple seconds
Yes.
do another plug
Yeah.
for me. It's
Absolutely.
now Javier did indicate that I'm an employment lawyer, and that's I do, and I really enjoy employment, but my areas are also real estate and just general business matters. Breach of contract, intellectual property, trademark infringement, et cetera, et cetera. Thank you.
Excellent. Well, Juan, I think we'll wrap it up. We're just at the 11 o'clock hour. I want to thank everybody for joining us today. This will be on YouTube, on our YouTube channel tomorrow, and we will have that available for you. Once again, thank you. Keep tuning in.
Javier?
Yes.
Just real quick, there's the question that we had asked previously about the statutory employee.
Yes.
They elaborated. It says, we have someone who only gets paid based on the sales they bring. They don't have hours they work. They control their own schedule. And the question again was, can a salesperson in the transportation industry be categorized as a statutory employee? And then they said, not sure if they are an employee.
I'm sorry, I did not catch that.
So the question was the one from earlier.
Uh-huh.
can a salesperson in the transportation industry be categorized as a statutory employee? And then they elaborated and said, we have someone who only gets paid based on the sales they bring. They don't have hours they work. They control their own schedule, and not sure if they are an employee.
As you may know, a couple years ago, at least in California, there's a legislation that was passed as a result of a case, and that now, and it's with regard to who is considered an employee and who is considered an independent contractor. And this case and the legislation that was instituted as a result of that, now it's more restrictive. It's very difficult for an employee to be considered an independent contractor. And generally speaking, and this is general, there's other requirements, but generally speaking, if the employee is performing services or a job that is part of the employer's business, regular type of business, then the argument would be that that employee is not an independent contractor. He's an employee, and you must comply with the laws. If it's an exempt employee, if the employee qualifies as an exempt employee, then you don't have to comply with generally some of the wage and hour laws. But if they are non-exempt, then certainly you have to comply with all wage and hour laws, meal periods, rest periods, overtime, minimum wage, all that stuff.
Great, thank you, Juan. I'm going to just now take that time to conclude our seminar. We'll stop the recording, Jennifer. Everything will be on YouTube. Somebody asked me the next March 15th, put on your calendar, March 15th, 10 o'clock a.m. we'll start our